People v. Danny Novas. Counsel?
Good afternoon, Your Honors, and may it please the Court. Andrew Stamboulides of Debevoise and Plimpton, in coordination with the Office of Appellate Defender, on behalf of Appellant Danny Novas. I'd like to reserve 3 minutes for rebuttal, Your Honor.
Yes.
Thank you. Your Honors, this case is about the failure to prove knowledge of injury, an essential element for the crime of leaving the scene of an incident without reporting. Specifically, it's about the prosecution's burden to prove beyond a reasonable doubt that Mr. Novas either knew or had cause to know of injury as a result of the incident he was involved in. Here, as Justice Klott correctly ruled when overturning the conviction, the evidence was insufficient to prove beyond a reasonable doubt that Mr. Novas either knew or had cause to know, where at most it showed that he had an awareness of some incident involving a side view mirror being pushed in.
So you acknowledged there was evidence, there was contact with the car. Wouldn't a reasonable and prudent driver want to check that to make sure, in light of his seeing the person before, that he wasn't injured or should have known that he was injured at that point?
Your Honor, the standard is whether or not at the time of the incident Mr. Novas would have cause to know or did in fact know that injury occurred.
Cause to know, a person was in the street, then he didn't see him. He said he thought he slapped the mirror, but there's contact with your car. If you think there's contact with your car, would you not have reason to know?
Your Honor, while the best practice in this scenario may be to evaluate what happened, the standard about whether or not he had cause to know of injury at the time, when there's no evidence that the car was speeding, the only
So it doesn't matter there was contact with his car and there was a pedestrian?
Your Honor, the fact that there was contact with his car involving the side view mirror potentially being slapped in does not indicate the type of forceful impact that other courts have held sufficient to prove knowledge of injury.
So he also described what happened as an accident. So, I mean, I've driven when a pedestrian had slapped my side mirror and I saw it happen. I knew it wasn't an accident. And so I wouldn't have ever described that as an accident. But he described what happened as an accident, which seems to me at least a piece of evidence against him.
Yes, Your Honor. There was testimony from York Peralta, a friend of Mr. Novas's who was with him and driving separately that night, that Mr. Novas called him and said either that he had been in an accident or that someone had hit his car.
Well, sorry, he testifies on direct, right, that it was an accident.
Yes, Your Honor.
That's what he was told. And then on cross, he says something a little different.
He eventually testifies that it may have been his interpretation of what Mr. Novas said.
But we take the evidence in the light most favorable to the people.
Yes, Your Honor. So viewing the evidence in the light most favorable to the people, if he told Mr. Peralta that he had been in an accident on the way home, the circumstances of that accident still offer no support for the conclusion or the reasonable inference that he saw, felt, or heard anything that would have apprised him of injury.
Well, isn't the jury free to rely on an inference that if his friends heard him writhing in pain, that they could have reasonably inferred that the defendant heard it? I mean, a lot of it is what's the defendant's defense versus what a jury can reasonably infer from the evidence, that he could see clearly because he saw the pedestrian, he could hear because he felt the impact or heard the impact on the mirror, but that's what he's saying. But a jury is free, isn't it, to come up with a reasonable inference that says otherwise?
Your Honor, the jury is free to draw a reasonable inference based on the facts of the accident that a driver would have been apprised of injury or have cause to know of injury. But in this case, as respondent concedes, it was raining that night, it was 3 in the morning, and the friends did not run over until 12 seconds after the moment of impact.
Because they heard the victim screaming in pain. And if the friends heard it from a distance, wouldn't it be reasonable for a jury to infer that the defendant heard it as well?
Your Honor, the friends heard it from that block and started running over 12 seconds after the accident at a time when Mr. Novas in a moving vehicle was not in close proximity to the scene. Furthermore, the pedestrian himself testified that he first fell down to the ground, realized he could not feel his leg, and then began calling to his friends.
So it was too late. Mr. Novas had
This was at a time when the driver was no longer in proximity to the scene, not in a position to hear the victim calling out to his friends. No one else.
What inferences can be drawn from the defendant's conduct and statements to the other passengers afterwards?
Yes, Your Honor.
Apart from the phone call where he says it's an accident, apart from that.
Yes, Your Honor. Based on Mr. Novas' statements after the incident, telling his passenger to push out the side view mirror because he believed an annoyed pedestrian may have slapped it in, The reasonable inference at most is that he was aware of some incident involving a pedestrian potentially hitting or slapping his mirror, that he continued driving.
So
and
then
there's-
why ask the other passengers whether they heard anything?
Your Honor, yes, there's testimony that he asked the passengers in the back seat whether they saw or heard or felt anything, and they replied no.
And then,
that's
and then
consistent-
when he got where he was going, as they say, he got out and looked around the car. He must have thought there was more than just the mirror.
Your Honor, there was no evidence on the record that he got out and looked at the car after. That was a former statement made by Ms. Villar in a statement with the prosecution that was
I
not
see.
admitted for its
I see.
truth at trial. But there was evidence that he asked people in the car whether they heard or felt anything, and that's consistent with, based on the accident we know and the facts surrounding it. that
What
he
about the
believes
way the
someone-
victim described what happened?
Exactly, Your Honor. The victim, in fact, consistently testified, and it's clear on the record that he was running from in between double parked cars while dressed in all dark clothing when he was clipped by the front right bumper of the car, pushed to the side further down, and made contact with the side view mirror.
So
This
if
is
the
not-
jury
but he
believes him, it's
also
the
s-
front right bumper, that
corner
would be
bumper
in
on the
your line of
passenger.
vision as the driver. Why would that not be a reasonable inference?
Your Honor, at-
Despite what the defendant may be arguing in defense, that actually would have seen that he hit this individual.
Your Honor, the types of evidence that have been found to be within the driver's vantage point or point of vision involve an accident where, and we cite them on page 25 to 27 of our opening brief, but they involve a pedestrian slamming into the hood, causing a dent in the hood, a pedestrian crossing at the crosswalk before being hit in the center of the road within the vantage point of the driver. An accident where a pedestrian dressed in all dark clothing, running from in between double parked cars at 3 in the morning on a rainy night and being clipped, as he stated himself, clipped by the corner bumper of the vehicle before being
And then I
pushed to...
believe he said he fell on the car, that's at page 146, pushed himself off it, was thrown to the side at page 145, and fell to the ground. So it's a little different than just clipping and he didn't see anything. If he fell onto the top of the car, as the victim has testified, that's different, isn't it?
Your Honor, he did not testify that he hit the top of the hood of the car for its truth. The prosecution the defense elicited a prior inconsistent statement he made at a civil trial that he had rolled over the car and slammed into the hood and windshield. At trial, he testified consistently that he was clipped by the front right bumper and made contact with the side view mirror, that his hand touched the bumper, but not the top of the car, not the hood, the windshield, the driver's side of the car, any area of the car that other cases have held sufficient to prove that a driver would have cause to have seen
Well, they
it.
may have been sufficient in those cases, and this is not the only thing that the people are pointing to. This is part of the evidence that the jury had available to it to make its determination.
Yes, Your Honor, and we cite to those cases not for the proposition that any one fact or set of facts is necessary to prove knowledge of injury, but the prosecution in this case does not cite to any facts not only the same as those facts, but even resembling them, such that they would apprise a driver whether it would be cause to see, hear, or feel something
What about
indicative.
the inference of motive? How should we consider that?
I'm sorry, Your
As
Honor?
opposed to sort of innocent, you're just going, of course, if I had known, I would have stopped. The suggestion of the motive that comes from, of course, the interview with the other police officer, that he's trying to protect his future in the police academy.
Yes, Your Honor. The prosecution cites to consciousness of guilt evidence that Mr. Novas was not fully forthcoming about his alcohol consumption that night and the fact that anything happened on the way home. And there's not a reasonable inference to be drawn from that he knew of injury or had cause to know of injury and was concealing that fact. This is a police cadet being interviewed by a detective aggressively at the time because the detective thought at this time that this was a purposeful attack on a law enforcement officer. And he's being asked about alcohol consumption before he got behind the wheel of a car. So to draw the inference, at most, you can draw a reasonable inference that he was downplaying his alcohol consumption before driving home that night and that he did not mention that his side view mirror had been pushed in by a pedestrian. But to take the leap and assume and create the reasonable inference that he knew of injury as a result of that interview, based on the facts on this record and how the accident occurred, is a logical leap that's unsupported by the record, and it fails to caution the advice of this court, which has held that a person in a police interview may not be fully forthcoming due to save his job.
Right.
A police cadet in this time may have made those statements for
And
that reason.
what about the nature, sorry, right here, what about the nature of the damage to the bumper? Is it something from which the jury could infer it was significant enough that the driver must have realized he had a pedestrian?
No, Your Honor, and the pictures of the damage to the car as seen on the appendix on pages 487 to 502 consist of minimal scuff marks in the bumper of the car, consistent with the accident as described by the pedestrian, that he was clipped by the front right bumper and pushed off to the side further down. There was not the type of damage held in other courts to put a driver on notice of injury, including, as mentioned, a dent in the hood, impact with the windshield, impact with the center of the vehicle such that a pedestrian was standing and hit by the vehicle in its center in an area within the vantage point of the driver.
And so, I'm sorry, is your argument in this regard that based on the nature, this clipping on the side of the bumper, that was outside the defendant's field of view? Or simply that the damage to the bumper itself has some probative element to it that confirms that the defendant couldn't have known just from looking at the damage that he hit somebody?
Your Honor, our point is that based on how the accident occurred, there's no reasonable inference to be drawn that Mr. Novas would have seen it, based on the testimony of the defendant about how it happened. The damage is a separate question, and it goes to the fact that...
Okay, I understand that. So I just want to confirm then, based on your answer to that, why is it that you're saying he couldn't have seen the vehicle striking the victim if it was clipped on the bumper? I don't understand the physics of that argument.
Your Honor, it was 3 in the morning, raining, when Mr. Gomez, the pedestrian, testified that he ran from in between double parked cars into the side of the road, the side of the vehicle where he was clipped by the right bumper.
He darted out quickly, and that may have obviously been a contributing factor to how this happened. But once he's out there and there's an impact, how do you not see that? Or how is it unreasonable for a jury to come to the conclusion that he should have seen that?
Your Honor, this is not an area of the car that's within the vantage point of the driver, and the fact that he pushed in the side view mirror on the passenger side.
Your bumper?
The front bumper of the
No
car?
part, when you're driving, you see the bumper, left to right.
Definitely the front center vehicle and the front bumper, and maybe even the front right bumper, but the corner on the side of the car, in a point where he's making contact with the mirror, he's clearly on the right side of the car. But the point about how the accident occurred and the victim's testimony in this case is that he's not testifying to, I see my time is up, Your Honors, may I briefly
Yes,
conclude?
please go ahead, yeah.
There's no circumstances on this record that the accident occurred in a manner that Mr. Novas would have reasonably seen it, heard it, or felt it. If you look at the cases cited in our brief on pages 25 to 27, they all involve facts that are extremely distinguishable from these. Prosecution cites to no facts even resembling them, and there's no evidence to support the conclusion that Mr. Novas would have reason to know of injury in this case. Thank you, Your Honors.
Thank you.
Good afternoon. May it please the court. Rachel Bond for the people. The defendant here, while driving pretty briskly down a New York City street, hit the victim hard enough to break the victim's leg, multiple bones, multiple fractures in each bone, and crack the bumper. It was more than scuff marks. There was a crack in the bumper directly below the headlight. And then he admitted that he saw the victim and that he knew he hit someone, and then he later lied about it.
Well, knew that there was contact,
Yes. He knew that he had made contact with the pedestrian.
or the pedestrian made contact with him. It was, right, that's not clear that he said, I drove the car into the pedestrian.
It's not clear from the record, however, there is a reasonable inference that that's what he said. Not only did Peralta testify that that's originally that he said he got into an accident, but additionally Peralta, the effect that defendant's words had on Peralta was very clear. He actually did a U-turn to go check on the defendant. There's a reasonable inference that whatever the defendant told him, it was severe enough that he felt the need to turn around and check on
So you're saying even if that witness disavows that the defendant used the word accident, it was whatever the defendant may have said that, as you're now, I think, arguing, it had the kind of, he interpreted it, he said, I interpreted it that way, it had that kind of severity. He viewed it as something severe had occurred.
Correct. He also did not disavow that that's what the defendant said necessarily. He said he couldn't remember what exactly the defendant had said, whether he said the word accident, whether he said that there was an incident.
I'm sorry, I don't have the record right in front of me. Did he say that was my interpretation or that could have been my interpretation?
Off the top of my head, I don't remember. I do believe he said that could be my interpretation, but I'm sorry, I don't remember off the top of my head. But just, again, viewing the facts in the light most favorable to the people, drawing all the reasonable inferences, the simply the force with which the defendant had to have hit the victim here was enough to apprise him that the victim was injured. Again, there was multiple
But see,
fractures.
there, I think maybe, and I'm thinking about some of the other cases where, for example, there's an accident reconstruction expert, or there's other testimony that links it together. There's nothing there, I think, from which you can say that because somebody has those breaks in their leg, that was caused by contact with the car rather than hitting the pavement, for example.
Well, I would
I'm
really
not sure how you make that inference.
I would really urge the court to look at the photos of the injuries. I think it makes it very clear that the accident happened the way that the victim testified that it happened. Otherwise, his injuries are just simply not explained.
Right, but that's different from the question of whether those are, Novus could have known, should have known, or did know, right?
So here, the jury didn't have to have expert testimony to explain to them that someone would feel that. You don't have to have expert testimony to explain common sense. The jurors are allowed to bring in their own real-world experiences. And as drivers, a reasonable driver would know that if you see a pedestrian and you feel that kind of force, again, to crack the bumper of the car from the impact of the
No, I
leg.
don't know about that. I mean, that real-world experience would have to be hitting somebody with your car, right? I mean, I'm not sure how you get that to know what it would be, what you would feel from inside of a car if you hit a person in the leg. I've never done it. I don't know what that would feel like.
I think the real-world experience comes from, as drivers, everyone has had maybe just a very minor accident or run over a large tree branch, to know what it feels like when you hit something, and to know that then when you're hitting someone with your car, and it's, again, that kind of significant force, you're definitely going to feel that. And that fact alone here gave the defendant cause to know that he injured the victim. He should have stopped. And then additionally, the fact that he then admitted to his friend, I got into an accident, or, I made contact with a pedestrian, when he told his front seat passenger to push out the mirror, and said
It
that,
seems to cut against you a little bit, because slapping the mirror in wouldn't injure the pedestrian, and it does make a pretty loud noise. So the other two pieces, I think, are, pretty strong evidence for you, right? Which is Peralta, and then asking the passengers, did you hear something? That suggests to me some doubt that it was actually the mirror.
I would disagree that the testimony about the mirror cuts against us, because I think even at the rate of speed he was going, if you watch the video, he's very clearly just driving down the street pretty quickly for a New York City street. Even if the victim had slapped the mirror, I think that could have caused injury to the victim's hand.
But I'm a little confused, correct me on the record. So the defendant and the victim both talk about contact with the mirror. So the victim is not saying, no, that didn't happen. It's just that the victim is saying more happened.
Yes.
So
Yes.
the jury could have relied on the more about the bumper and whatever else he said?
Yes, again, drawing the reasonable inferences in favor of the people and viewing the facts in the light most favorable to the people, the jury, this court should find that the jury credited the victim's testimony and that is the way that the accident occurred. And he testified very consistently about the way the accident occurred and about how he fell to the ground, that the bumper hit him in the lower left leg, and then he fell, he made contact with the side view mirror, and the damage to the car corroborates that as well. There's a crack in the bumper right where it would have hit his leg. There are scuff marks and scratches on the bumper. There's one scratch leading up the side of the hood. So
It all seems to
it's-
go to whether the accident happened, and I don't think there's any question the accident happened.
Well, I think it just corroborates the victim's testimony about how the accident happened and how he received his injuries.
Did he say what part of his body hit the mirror?
I believe he just said,
Came into contact?
I believe that he said that as he fell, that he also made contact with the mirror. He may have said his hand had made contact with the mirror as well. So
His hand?
he may have said his hand, but I believe he was talking about as he fell.
But he didn't
that-
testify that he was slapping the mirror, did he? Out
No,
of
he testified that
anger
he-
or frustration or something?
No, he testified that he hit the mirror as he was falling. And again, the damage to the car sort of corroborates that. There's a scratch. And also, if you watch the video to see that the defendant doesn't stop his car, it makes sense that if he got hit and then he fell, he didn't do any sort of, he wasn't propelled into the air or anything like that, it would make sense that he would hit that mirror based on where the crack in the bumper is at. And Just additionally, as to the other evidence that was discussed during opposing counsel's argument, he also tried to distance himself from this accident. There is a reasonable inference
Well, that could be from the drunk driving.
It could be, but again, all reasonable inferences for the people here. There's also the inference that he did it because he knew what had happened. And again, he didn't just lie about the alcohol consumption. He lied about what time they left. He lied about anything happening. He lied about the alcohol consumption. He did everything he could to distance himself from the accident. And again, this is just extra consciousness of guilt evidence. It's not necessary to prove that the evidence here was legally sufficient. That comes from the impact with which he hit him and his own admissions that he knew he came into contact with a pedestrian. And
what about his friends hearing him scream after he was hit? Was there a reasonable inference that the driver could have heard that?
I think that's certainly a reasonable inference. I know that the victim testified that he fell and then felt pain and then started screaming, but I think this all would have occurred in a very quick succession, almost simultaneous. And I think the fact that the victim's friends heard him from a little over a block away, it seems from the video, even considering the rain and, you know, the train overhead, that it's reasonable that the victim started screaming while the defendant would still have been in earshot. It's a reasonable inference that they could have made. And again, I think that
Is there any evidence about whether or not the windows were open on the car?
there was no testimony regarding whether the windows
Can
were
you tell
open
in
or
the
not.
video?
I'm sorry?
Can you tell in the video?
No, it's not very clear from the video. I mean, the windows could have been cracked or fully open. I'm not sure.
You can tell it was raining, though.
Yes, you can tell that it was raining. However, the video makes it also very clear that even though it was raining, even though it was dark, the area was pretty well lit. There were a lot of cars that night, and so they all had their headlights on. There were lights from the businesses. The victim is very clearly visible running into the street.
Yeah, no, I just meant it'd be pretty unusual to drive with your windows down when it's raining.
Yes, no, and I'm not saying that the windows were necessarily, were down. There is no testimony one way or the other on that.
If this were to go in your way, defendant would have a weight of evidence motion available to him if it
Yes.
went back, wouldn't he?
Yes, because this is based on the reversal, the setting aside of the verdict from the trial court.
Right.
Yes. So yes, he still has a weight of the evidence claim available. And if there are no further questions, we would just ask that you affirm the appellate division's order.
Thank you.
Thank you.
Your Honors, I'd just like to address a few quick points on rebuttal that respondent argued. First, the fact that there was a serious injury here is not in dispute. It's a separate element of the crime, and Mr. Gomez did in fact break his leg. He required medical attention at a hospital. That's not being argued today. The reason it's a separate element of the crime is, as Your Honors have noted, the facts of each case are unique. Not every accident occurs the same way. And the way that this accident occurred, as consistently testified to by the pedestrian himself, is that he was clipped by the corner bumper of a car and pushed in the side view mirror. At the time, the driver, Mr. Novas, asked his passenger to push out the mirror, which he had thought had been slapped in by an annoyed pedestrian, and he continued to drive home. The other evidence cited by respondent is that there was a crack in the bumper. Your Honors, again, I'd direct you to look at the appendix on pages 487 to 502, which show a few scuff marks and a crack literally that big on the lower bumper of the car, consistent with the testimony that he was clipped below the knee, above the ankle on the white SUV that Mr. Novas was driving, which is at a low point, not within the vantage point of the driver, especially when on the corner of the vehicle. And
To Judge Canataro's point, aren't you really making a weight of the evidence argument and not a sufficiency?
no, Your Honor, this is drawing all reasonable inferences in favor of the people and looking at the evidence in the most favorable to the prosecution. There still is not a reasonable inference that Mr. Novas knew or had cause to know of injury on these facts. And looking at the cases that have found knowledge of injury or cause to know that injury occurred, they do not consist of facts like these. There is no case that respondent cites to remotely close to facts like these because there are none, and the acquittals wouldn't have records of those decisions. The fact about him possibly hearing the screaming, I just want to point out, not only was the window most likely or definitely closed on this rainy night, but it is clear on the surveillance videos that his friends did not run over to him until 12 seconds after the moment at which the impact would have occurred. At this point in time, as clear by the surveillance video, Mr. Novas's car, which was continuously driving, was nowhere near in proximity to the scene.
I mean,
which-
but can't that also mean that they were 12 seconds away, so they heard the scream, and by the time they got back, it took them 12 seconds?
Your Honor, the surveillance video reflects them slowly walking down the street outside of the bar that they were at. They're within a block and a half of the accident. Mr. Novas's car moving for 12 seconds is nowhere near proximity of the scene, and there's no evidence that he would have heard not only the moment of impact, but the screams or calls, or the calls of Mr. Gomez when his friends came running 12 seconds later.
So was his testimony that he heard the rear view, the side view mirror, or that he felt the impact?
The testimony of I see my time is up, if I may briefly respond and conclude. The testimony of the passenger of the car was that he told her to push out the side view mirror, which she understood him to believe that an annoyed pedestrian had slapped in. There wasn't evidence about how he knew or why he thought that, but that's all that was on the record. And for this reason, Your Honors, even viewing the light in the most favorable to the people, there was not proof beyond a reasonable doubt that Mr. Novas knew or had cause to know of injury on this record.
I'm sorry, just to be clear, the personal injury under the statute, for purposes of what he's convicted of, does it have to be grave or serious?
Yes, Your Honor, serious physical injury.
Or what he was convicted of?
Yes. Thank you very much.
Thank you.